Good evening, everybody. I'm Yasminka Hasanbegovic, retired professor of this faculty, and I'm going to moderate this event this evening. I'm glad that we have here Vice Dean, Professor Nina Kršljanin. She's going to formally open this event.
Thank you very much, Professor Hasanbegovic. Good evening, Professor POSTEMA. Good evening, dear colleagues, dear friends. It's my honor to open this event tonight, to welcome you to the Faculty of Law of the University of Belgrade, to transmit the greetings of our Dean, Professor Zoran Milkovic, who unfortunately could not be with us tonight. It is a great honor to have you at our faculty. It makes me very happy that such an interesting half symposium, half book promotion is organized here. It's a great pleasure to have all our colleagues from other faculties, both these present in the hall and those with us online. It's a pity that we can't have you all in the room with us, but I'm sure the technology will enable us very good interactions even in this way. Without further ado, my talk is finished, so I'm giving the floor to you.
Thank you. May I stand or sit? What would be best?
I would like just to say a few words.
Of course.
And you may have your talk sitting.
Okay.
Dear Professor POSTEMA, it is an exceptional academic, cultural, and intellectual honor for all of us to have you here today as a speaker on the topic of the rule of law. Thank you sincerely. We are deeply grateful to you for your willingness to devote some of your time, that is your life, to us and to share with us your vast knowledge. It is also my duty to thank Professor Kršljanin, Vice Dean for Scientific and International Cooperation, as well as Professor Jovanovic, Director of our Faculty Center for Fundamental Legal Research, for making this event possible. The last, but not the least, I would like to thank all the colleagues, great admirers of Professor POSTEMA'S work, who have joined in this endeavor to critically shed light on his research and contribute in their best scientific way to the achieved values of his results. They are from different universities: Ankara, Athens, Banja Luka, Ljubljana, Lodz, Osijek, Palermo, Skopje, Trnava, and Belgrade, of course. The audience will get to know them by name and their ideas right after Professor POSTEMA'S talk. But I have to say that there are many more who are also very eager to listen carefully, maybe next year, and to talk with Professor POSTEMA about the rule of law. So, without any further delay, let's get to the heart of our topic, the rule of law, nature and value, threats and challenges. Professor POSTEMA, the floor is yours.
Hvala. Thank you so much, Professor and Dean. It is an enormous pleasure and great honor, I should say, to be here. The honor is obvious to gather together with dear colleagues, new and not so new. Many of those, I am grateful to say, on our screen. Been longtime friends and colleagues over many years, and it's really delightful to have a chance to interact, even if virtually, here. It's a special delight to me, I must say, to see as many students around, younger people, not folks my age. I retired 4 years ago, and I rarely have an opportunity to talk with folks of your generation, and it is enormous pleasure to me, and I hope that I can give you something to think about. To begin, the title, the term, the phrase "rule of law" has been around for a long time, but it tends to be, it used to be used as a kind of commonplace amongst lawyers and familiar to lecture halls, but not very much publicly talked about. That's changed greatly. So now politicians and political writers and pundits and even people in the public square use this term. But it's a term that's overcome by contest or contestation or dispute and what I like to call capture. There's across the academic literature on this topic, there's a wide range of views, lots of contesting views, and also in the public square. Sometimes the rule of law is identified simply with law and order, or as I like to call it, order and orders, without very much law there. Or it's identified with the protection of property, or maybe with the advancement of certain human rights, maybe even economic justice. There's a lot of dispute. But also, there's been an attempt to capture the term. My favorite poet, Dante, once said, "Justice is so lovely that even its enemies love it." And if that's true of justice, it's even more true of the rule of law. The term rule of law has a kind of halo of legitimacy, which those who are its enemies would like to capture without having to submit to its costs. This is worrisome because in our contemporary time, the time we are now living in the time of international threats within many of our nations, the rule of law really is under challenge and threat. So we must take a proper measure of this notion. That's the task of Law's Rule. That's the task of this book. The aim was not to settle disputes so much as to provide a kind of structure for us understanding better where our disputes, our disagreements come up and how we might then navigate those disagreements, perhaps make some advance, some greater understanding. So I want to do this through two things. One, through what I want to call the architecture of it, and then through articulating and defending a particular conception of the rule of law. The architecture takes this form. Identify, first of all, some distinctive features of the ideal of the rule of law. First thing to keep in mind is that the rule of law is not the rule of just any old laws. The rule of law is not satisfied by the existence of laws. My friend Martin Krieger, whom I will mention again later, said in the Stalin era, there were lots of laws and lots of rule, but not much rule of law. Law is capable of both majesty and monstrosity, greatness and problem. So the rule of law itself imposes important constraints on law itself, demands things of the law and of those who wield the law for the purpose of wielding their power. So it makes costly demands. But also, the rule of law is just one ideal of political morality amongst others. So we have to keep them distinct, try to find its core of meaning and demand. And finally, because it makes really serious moral demands on us, we have to ask why. On what grounds? That is, it has to be rooted in something more fundamental yet. So the strategy of this book and the strategy in a bit in my talk will be, first of all, to identify the core ideal and 3 principles that seem closely related to it. That's strategy 1, part number 1. Secondly, one needs to articulate the moral foundation on which that ideal rests. And I'll say a little bit about that. But the rule of law is what I want to call an institutionally realized ideal, meaning that it gets its force and power through its articulation in institutions, rules, norms, and practices. And so we must ask then, how is this ideal? And these principles that I will identify, how are they realized in institutions? And to do that, we must work from the core ideas and the principles that follow from them, keeping in mind the underlying foundations, but also keeping in mind also that cultures, political structures, material economic structures of different countries will be different, and so we will have to adjust our understanding of the appropriate, most effective institutions relative to the core, their foundations, and those variable social and cultural contexts. All right. For our purposes, I will simply state what I spend chapters arguing for. Something about the main core idea of the rule of law. The rule of law is concerned not with disorderly behavior, but with disorderly power. Its concern is with the exercise of power, specifically with the arbitrary exercise of power. And it takes law as the tool by which it tries to protect, tries to constrain, and constitute that power. So what I want to say here, you can write this down, or maybe it's written down there, and keep it in your back pocket. The rule of law, when it thrives in a political community, the rule of law provides protection and recourse against the arbitrary exercise of power through the distinctive tools of law. Notice that identifies an aim and a means. And the conception of the rule of law I want to articulate is one that takes that aim and means seriously and seeks to work out its implications. So the organizing aim, then, of the rule of law is to temper power. The rule of law acts as a kind of bulwark, a kind of walls protecting the powerless, but also a bridle, a constraint, a way of guiding that power, a bridle on the exercise of ruling power. But for it to work as a bridle, it's not enough that those who wield ruling power profess their willingness to follow the law. Their subjection to the law must be one that goes beyond their mere professing their willingness to do so. They must be held accountable. To be subject to the law is to be accountable to others for our performance with respect to that law. And so, accountability is at the very core of the idea of the rule of law. You might say accountability is the necessary complement to law's guiding function. Now, if you accept my proposal, that's the core, I think 3 interesting principles follow directly or spell out that core. All right, they're on your sheet. And because I'm a philosopher, I like more and more distinctions. And so there are three principles, and one of them has three principles. Right? The first one I call sovereignty. Sovereignty is the idea, the principle, that law alone must rule. Law alone must rule. That I break down into three sub-principles. One, I call exclusivity, that governing power is legitimate only when it is ordered by, structured by law, only when it's authorized by law. Secondly, legality is the idea that law must be, power must be exercised only through law. And finally, reflexivity, which is the idea that law governs everyone, even those who exercise power through law. So those who are governed and those who govern, all of them must be governed by law and so held accountable to it. That's one. Well, it's three, but it's one. Secondly, equality. This is equality for the purposes of rule of law, not equality in general. For the purposes of law and of rule of law, equality means equality in the eyes of the law, which means law's protection and its recourse must be available to everyone on an equal basis. That's the second principle. The third principle, as you see, we arrive at it in this way. We have to recognize that laws and institutions cannot protect themselves. They're incapable. Only when there is an ethos of support for those institutions and laws could it be possible for law to rule. You might want to say law can't rule without there being in the political community an ethos that I'm going to call fidelity. Right? Fidelity is this important principle. All members of the political community are responsible for holding each other, and especially law's officials, accountable under the law. Everyone has a responsibility to hold each other, and especially political authorities, according to the law. Law can only rule when this ethos is deep and strong in a political community. Fidelity, I argue in my book, is the animating spirit of the rule of law. All right. But I say the rule of law aims to constrain and constitute power through law. We need to ask, are the distinctive tools of law? We need to ask, what's in the toolbox? What's in law's toolbox? Now, very broadly speaking, I wanted to identify three or so, four maybe, properties of law. I won't mention all of those on the list. First of all, laws are positive. They're the product of human activity, human invention, and so they are liable to change. But laws are normative. This is a crucial element here. Law seeks to order behavior by addressing norms to law subjects. That is, law seeks to order behavior not by goading people, by causing them to do something. Imagine the snake charmer making the snake dance. It provides norms that address those who are capable of grasping them and making use of them in their individual deliberation. That's a distinctive technique of law. Third, law is public in two respects. One, it's addressed to a public, a community in general, not just to this individual or that individual, but to a community in general, a kind of public, if you will. And law makes the exercise of power public, visible. Right? Fourth, and this is a crucial thing, law, as I understand it, is a discipline of deliberative reasoning. Law does not govern by reason. Law governs by deliberative reasoning by providing us with reasons that we can assess, offer to each other, assess them, criticize them, accept them, reject them. Law is focused on deliberative reasoning, not just on, not at all, on reason as a simple concept. Finally, law works through institutions. I mentioned this before. So law is importantly institutionally realized. So keep those tools in mind. We need to talk now about the moral foundations of the rule of law. Mind you, we're going very, very fast. This is several chapters. We're going one chapter after another, galloping through. My claim is this. The rule of law, its particular kind of normative demand, the rule of law makes on laws and on those who wield power. The particular demand can be explained best in terms of a moral concept I call membership. It's not a familiar term, but you'll see how I want to make it work in a moment. Membership offers a kind of vision of a community that can work together, a community that's bound by, of members that are bound by history and by interdependence, and not, where members are not subject to other individuals, but are somehow reciprocally related. So, a membership community, I might want to say, a membership community is characterized by, one, mutuality, by which I mean they are bound by mutual commitments and by mutual responsibilities. Their relationships are ordered by mutual obligations. Each has a part. Secondly, a membership community is characterized by what I call peerhood. You might call this equality, but I like to call it peerhood because the idea is that not that everyone has the same amount of something or other. It's that everyone has the same place to stand, that each can look the other in the eye. I love to do it. Each can look the other in the eye without a sense of subordination. You stand as a person in the eyes of another person. Third, it's concerned with inclusion, but inclusion that takes very seriously the diversity amongst us. So it's inclusion that doesn't demand others give up their diversity. It requires that diversity be recognized, respected. I like to think of it not, perhaps you know the phrase on American U.S. coins, e pluribus unum, out of many, one. And I say, no, that's not right. It's not e pluribus unum. E pluribus, and if I had my Latin right, it would be e pluribus, a fugue, a polyphony. You know, fugues are different lines that work together, and they make a kind of whole, a rich whole, musical whole, of different lines that are intersecting. That's my idea of the out of many, a fugue. Now, in light of this, it's very important to see that you can respect dignity, respect purehood and diversity only if you respect the dignity of each individual. So following from this is a very important principle of respecting dignity, and because peers have to be able to see each other without subordination to the other. A notion of freedom as non-domination, freedom as non-subordination becomes really important. So the idea of membership then is a kind of umbrella term that brings together 5 different important values that are complementary and mutually limiting. Mutuality, purehood, a kind of equality, a kind of dignity, and a kind of freedom. Those are all wrapped up into this package. Now, when you think of it, if law meets the demands of the rule of law, adequately, it's going to serve that important value, that important combination of values. My claim here then is when law, it meets the standards of the rule of law, it serves to build and maintain communities that meet the ideal of membership. All right, galloping on. The rule of law is an institutionally realizable ideal. That's the rule of law. Its aim is not to disable power, but to discipline it through the design of institutions. And so when we think beyond these abstract principle terms to what it would be like to think about the rule of law in place in Serbia or in Slovenia or in Argentina or in the United States or elsewhere, let's hope someday they will be. Hope they're not threatened. We need to have certain kinds of institutions in place. And let me just mention, so broadly speaking, the kinds of institutions or the principles by which these institutions should be designed. One of them is raw ruling power must be channeled through the law. And those laws must meet important standards of what are sometimes called legality. That is, the laws must be general and prospective, intelligible, and the like, but also those institutions that are designed to administer the law and adjudicate under the law must guarantee impartiality, must guarantee a good bit of access, equal access to these institutions. Parties leading them must be fair. Secondly, governmental institutions themselves must constitute and constrain and sanction the exercise of ruling power. And so those institutions might take, in the more familiar Western form anyway, a system of checks and balances, of separation of power, where each department or sector of government it has its own independence, and yet it is subject to the accountability of another department, another sector of that government. And these must be structured in such a way, both in terms of the larger, usually three parts, executive, legislative, judiciary, but also within those departments must be structured in such a way as elements are holding each other accountable in a framework of what I like to call horizontal accountability, horizontal within the structure of government itself. Thirdly, informal norms and practices must underwrite these formal institutions. Formal institutions will never be able to do this on their own, and so there must be informal practices developed by those who are part of those institutions to keep the mechanism working. Fourth, there must be, this is really crucial, there must be extra-governmental institutions, associations, organizations, rooted in civil society to perform what I want to call vertical accountability. Institutions within the civil society itself that can then organize the activities of fidelity of members of the community to hold those public officials accountable. What are important institutions? Well, first and foremost, free, independent media, press. Secondly, I think universities play a crucial role in educating, preparing, motivating, and disciplining, equipping people to engage in their fundamental civic responsibilities of accountability holding. Also, NGOs of all sorts, maybe also professional associations, maybe even labor unions or the like. These institutions are necessary mechanisms of what I call vertical accountability. And finally, maybe I can address it to many of you who are, I take it, law students. Most of you? even if not, listen. What's really crucial for the rule of law is a dedicated legal profession, a legal profession that's committed to the rule of law and its fundamental values. Lawyers and judges are conservators of the law. They're guardians of its integrity. But they're essential intermediaries between the law and public officials and ordinary citizens. I mean, the law is just too complex for any one person, even well-trained, even trained in law school, to manage it yourself. We all need access to those legal professionals who can help us move the levers of power. Lawyers also play a critical role in holding public officials accountable. They, as we sometimes like to say, they can speak law to power, both in their advising capacity and in their organizing capacity of their clients and others in the political community. Now, in my book, I talk about threats and challenges. I think of challenges in two ways. One, a challenge to the idea of the rule of law is a challenge that takes this form. Rule of law? Get serious. There's nothing there. It's an empty wish. Or it's an unintelligible concept. Or it's a pious pie in the sky. There is no such thing. I call those challenges to the rule of law. I think those challenges can each, in various different kinds, be answered not by saying we've got the rule of law already in place, but by rather saying that the problems that you identify are not challenges to the rule of law, they're challenges against the rule of law, they're challenges to us to do what we can to realize the rule of law in the face of significant threats. And I want to talk about those threats. Okay. And as I say, I'm a philosopher, so I like to make distinctions, and I want to distinguish two kinds of threats: acute threats and chronic threats, acute or active threats and chronic threats. Acute threats arise, now listen to this carefully, acute threats arise when the actions or activities of those in power breach rule of law institutions or laws, and the accountability response is weak or compromised or mute. Notice I distinguish between violations or breach of laws or principles of the rule of law or its institutions and threats. The threats come when the violations are not adequately responded to. I think of the rule of law as a kind of homeostatic system, where the rule of law really requires certain kinds of activities, but it recognizes that laws will not always be followed, that norms will be violated, that people will try to take advantage of those norms. It's aware of that. That's why mechanisms of accountability are so crucial. So the violations, the breaches, upset the equilibrium of our homeostatic system. But if that rule of law is robust and healthy, those breaches will not constitute deep decay-introducing threats. When there are parties around, when there are people around, when there are institutions around that can exercise the accountability necessary to challenge those very violations and breaches. Chronic threats, on the other hand, go beneath this. Chronic threats are the kind of atmosphere within which we live, in which it's difficult for the key motivations and commitments of fidelity and accountability holding, it's difficult for them to survive, to thrive. I want to talk first about some acute threats. Justice Khanna of the Indian Supreme Court back in the 1970s said this: 3 marks of decay of the rule of law in a political community are a docile bar, a subservient judiciary, and a choked and coarsened conscience. I want to build on that. Right? What's interesting about this is that Khanna distinguishes maybe 2 groups here, 2 groups of those who may exercise accountability. One, I'll call first responders. You know what first responders are? And those are the emergency people, the fire people, the police and the like that come when emergency happens, and they kind of settle things down and make sure that they can be managed. So he identifies first responders, namely lawyers and judges. I want to add to that political officials, elected officials, perhaps others of that kind. But then there's another group. I'll call them auxiliaries. That's the rest of us in the political community that don't have, as lawyers and judges and the like have, the position and the power and the recognition which they can use as resources for engaging in these extremely important activities of accountability holding, right? So, we can look at acute threats first. So let me just mention a few of these just very quickly. Sometimes power wielders who are not publicly but in their heart of hearts, blatant enemies of the rule of law. And sometimes they can defiantly violate formal laws or informal norms, but they often do it while loudly insisting that they're following the rule of law. Loudly insisting that they're upholding, even venerating the rule of law. Remember Dante. Even those enemies love it. They love it publicly. They hate the constraints privately, and they will do everything they can to undermine them. Sometimes so then they act blatantly in violation of the norms while saying, no, we're not doing that. Or that's not our rule of law. That's someone else's rule of law, not our rule of law. Secondly, what often happens is that they engage in intimidation or harassment, either their own security forces or their supporters, who then engage in the harassment of those who are potential sources of challenge with the blessing of, or at least with the tolerance of, those in political authority. Thirdly, those who wield power often work very hard to enlist and co-opt and corrupt judges, lawyers, and other officials, deploying the law, using the law, abusing the law against the law itself and against the rule of law. Let me give you a couple of examples of this. There were many examples early on, well into the COVID pandemic, where those in political power would gathered their own much greater sources of executive power without legal constraints. Sometimes legal academics call them legal black holes. They could act, as it were, with the authorization, but they're expanding their power. So an important, worrisome point. Sometimes anti-terrorism laws are used. Sometimes, especially where the judiciary is the target, a very common target and a very serious target. The attack may be through disciplinary actions or enhanced retirement proposals, the way to remove people from the judiciary who are troublesome, and put in place those who are loyalists. I just learned last week that my own state of North Carolina, in an appropriation bill, that is a budget bill, not legislation proper, but a budget bill, introduced and created 10 new courts of first instance, with judges to be appointed by the majority party. Notice how it dilutes the judiciary and puts at least some of them under control. I mean, there's more to that story than I can tell you, but you can see how you use the law. They were using legal processes, but they were using the law against the law, using the law against rule of law. Now, these are not just violations, these are threats. Why? Because adequate response to them did not arise. That's the key. Why didn't political officials cry out? Why didn't the first responders do? Actually, at sometimes they did, and sometimes they didn't. So I don't want to be entirely pessimistic. But where they failed, one might say, what's the source of that failure? And it might just be, and I think it often is, a failure of integrity of those in those positions. If you will, a moral failure. But the failure might go deeper than that. Maybe not just in the hearts and minds and souls and conscience of those individuals. It might go deeper into the moral climate. So I want to talk about the chronic parts of this. After all, the moral climate in which we live provides essential nutrients, if you will, for individual integrity. Conscience needs education, models, support, correction. Individual conscience lives and breathes in a moral climate, and that moral climate, if it is infused by toxins, can really undermine, can really serve as a threat to the rule of law. I want to mention two threats very quickly, two chronic threats. One of them we might call apathy and or alienation. Apathy just being people don't care. They're indifferent to the values of the rule of law. They're indifferent to the values they serve. Alienation, it seems to me, is even more complicated. People might just say, what is it to me? Political scientists often ask the question, what is it that would motivate those who wield power to submit to the law? Why would they do it? What's a constraint on them? I think a more interesting question is, why do ordinary people submit to the law and submit to the, if you will, the disciplines of fidelity? My friend Martin Krieger, I mentioned before, said there is this old proverb that law is like a door in a meadow. You can walk through it if you want, but what's the point? If that attitude gets deep into the heart of our community, if you've got that kind of alienation, that law can't speak to people anymore, then it will be impossible for the animating spirit of the rule of law to get going. Under what conditions might this alienation occur? Many different ones. Amongst them would be the distribution of economic and political power is so unequal that what the law appears to those who are on the bottom is not a bulwark of protecting of themselves, it's a bulwark of protecting those who exercise power. Not a bulwark of protection of the powerless, but a way of protecting and advancing the interests of those in power, the powerful. Another problem, chronic threat, I call the narrowing of the horizons of moral concern. By this I mean where the horizon of our moral concern, the limits of it, are determined by those who are close to us, by those who are like us, those who are near to us in some way or other. And when that happens, it may be impossible for us to see common needs and common efforts to meet those needs. I'm mindful of what happened in my state and elsewhere in the United States during early days of COVID, where the authorities were trying to convince people that this was a common threat and we need to engage together to find some common solutions. And one of the solutions was masking and standing in distance and so on. And in my neighborhoods, it was a fundamental moral right that you don't have to wear a mask. And they would go to the barricades for it. Suggested a kind of weakness here, a kind of sense that the very possibility of there being a common need that called for common effort wasn't available to them. It's a fundamental problem for the rule of law. I want to conclude by looking at one or two, maybe just one, problem that's still acute. And I'm mindful most of how it's working in my country. And that's the corruption of public discourse. The media are constantly inundated with disinformation, lies, falsehoods, conspiracies of various kinds. So much so that it's hard to get a grip on what could be true and what not. This is not just a matter of what sort of happens when you don't have constraints on things. It is a concentrated effort of those who exercise power to weaken the constraints possible on those who are exercising power. Brazen defiance of public norms has a corrosive effect on the moral community itself. When people say, look, he can do it, why can't I? And the constraints on our concerns about others, our secret wishes to dominate others, come out into the light. Corruption of public discourse by, some people call these power lies. Have you ever heard that term, power lies? The power lie is the lie that a bully makes when he takes the cap off of your hat, puts it on his head, and said, no, I didn't do it. Everyone knows that he did it. Doesn't matter that it's not true. What matters is that he's got the power to say it. Power lies. Pretty worrisome inventory of threats, wasn't that? I don't want to leave you with that. I don't want to leave you with that at all. What do we do about this? A couple of things we can say by way of response. One is we have to be fully aware of these threats and their sources, to see them for what they are and where they come from. We have to scrutinize so-called reforms and don't ask simply, does this reform conform to the law, but what's the political payoff for it? We have to get social media under control. I don't know how to do that, but that's what we got to do. Thirdly, we have to enhance the transparency of governmental actions and strengthen protections of the media, of civil society organizations, and peaceful protest. But institutional reforms are not going to be enough, I think. We must revitalize our moral environments. We must energize those first responders, hold them to their accountable themselves, demand their integrity. We must rededicate ourselves to the institutions and the values of the rule of law. We must moderate polarization as much as we can. And finally, we need to encourage, wherever we can find opportunities, need to encourage social trust building. Crucial. Ultimately, the rule of law is our responsibility. It's a collective responsibility in which each of us has a part. The rule of law thrives in a political community when members who are committed to the rule of law are determined through their vigilance to ensure that it's respected. I think we can do this with hope. Václav Havel said, hope is not something we work for because there's a chance of success. hope is working for something because it's good. And I don't mean good in the sense of sort of nice but optional, like a nice after-dinner drink, brandy after dinner, like. But good in the sense that it's right and compelling. That's our job. Thank you.
Thank you, Professor Postema. It was really, as you write, clear ideas and a summary of a very complex topic, and possibility to everybody to have some more precise idea, even those of our students who I suppose didn't have opportunity to even to blather the book. And that is the first part of our symposium. I suggest to have now a 5-minute break, and then to start with the second part. And the second part will be something that can be named brainstorm. I prefer French expression, tempête intellectuelle. That is to say that in this second part, the invited participants, scholars from different universities I mentioned at the very beginning, are going to ask, to put questions, to give comments to this very, very rich and interesting and very complex and sometimes idealistic book on rule of law. I suggest this 5-minute break, and then to start with this second part.
Good.